Good afternoon, everyone. Thank you for joining us today for this Philanthropy Roundtable webinar. I'm Debi Ghate. I'm Vice President of Strategy and Programs, and it's my pleasure to welcome you today. Our conversation today is going to be about what about the kids, advances in protecting the rights of children. And this is a topic I have really been looking forward to sharing with all of you. There's been a lot of news on these fronts, but first, why would the Roundtable host this conversation? For the Roundtable, our programmatic work has three important themes: America's founding principles, pathways to opportunity, and strong communities. And when we think about what it takes to help children succeed, all children succeed, it really requires a combination of these things, as we are going to hear more about today. So, some context setting. There are about 440,000 children in the child welfare system. And I hope that number is a good estimate. Here's a number that really surprised me. About 18,000 go missing in a year. 18,000 foster children go missing in a year. There were also 48,000 children involved in the juvenile justice system. It's quite a few. That's in 2019. And approximately 500 of those children were under the age of 13, right? So for those of us who really do care about what is going to happen to the next generation, the juvenile justice system and the child welfare system are very, very important for us to understand. They both deal with one very vulnerable population, and kids are actually circulating and cycling between different government agencies, sometimes living in facilities. So my question is, are the rights of these kids protected in these systems? Are we living up to our view that children are precious and that every child has the potential to flourish? Do our systems match those sentiments? And what are we doing about it if not? I'm really excited to welcome three experts who really are doing something about it. And there is going to be a lot for us to talk about. So I have with me today Tim Keller, Senior Vice President and Legal Director at Gen Justice, Jake Horowitz, Director of Public Safety Performance Project at the Pew Charitable Trust, and Frank Cervone, who's the Executive Director of Support Center for Child Advocates. What we're going to do today is have a conversation one-on-one with each of our guests, and then bring them all together so that we can have a conversation together and take your questions. So please do feel free to drop your questions in the Q&A box as we go along. And so we'll be looking for those. Sometimes we might answer it during the conversation. Sometimes we might take it in the Q&A. But either way, we're going to try and get as many of your questions in as possible. So Tim, why don't you join me on the virtual stage so that we can get started. Hi, Tim. Welcome.
Hi. Well, thank you for having me.
Yeah. So Tim, you've recently joined Gen Justice after a very successful litigation career at the Institute for Justice. And that was in school choice, right? But what does Gen Justice do? Because it's a relatively new organization. What does it do?
Yeah, we're about 3 years old, and Gen Justice works in legislatures and courtrooms to mend the broken child welfare system. We want abused and abandoned children to have families that they desperately need, and we want them to have the justice that they deserve. And so we do this by working on what we call 3 levels. This is the micro, the macro, and the super macro. And so at the micro level, we help individual children in their court cases day in and day out through our pro bono children's law clinic. We provide emergency legal assistance and counsel to children, foster families, kinship placements, whenever we feel like there is nobody in court speaking up and advocating for the rights and interests of the children in their own cases. And then at our macro level, we're changing laws to change lives. We work in our home state of Arizona to implement nonpartisan reforms and then share our work nationwide, helping local communities tailor reforms to their needs. And since 2017, when Gen Justice launched, we've worked with local leaders, national partners, to drive the adoption of state and federal policies that have impacted literally hundreds of thousands of kids. And these measures have expedited the search for relatives, shortened the time to adoption, and improved legal representation for abandoned, abused, and trafficked kids. And then finally, the super macro. That's where we seek to enforce constitutional rights. We believe that children are entitled to due process and equal protection. We also believe that every child deserves a family. And so our public interest legal work at that super macro level seeks to vindicate the constitutional interests of children to be free from severe abuse, and when abandoned to the state, to be adopted in a timely manner.
So that was a lot, because there were a lot of issues in there around due process and constitutional rights. I want to break it down just a little bit, because it may be a surprise to some people. It was to me. And I actually think it was Frank Servone, who we're going to hear from later, that kind of opened my eyes around this. Some may be surprised to hear that kids in the child welfare system don't have a guaranteed protected right to legal counsel, even if family members do or others do, right? And when we think about our criminal justice system and how every defendant has right to counsel, and there isn't an equivalent protection for children in our child welfare system in every state, that's surprising, right? So how can that be? And what can we do about it? I know you just mentioned doing something in Arizona. So how can that be, and what can we do about it?
Yeah, well, you're right. I mean, the fundamental rights of children are at stake in these abuse and neglect proceedings in court. The state has the power to remove children from their homes. The court has the power to determine who they live with, for how long, how often they get to see and visit with their biological families, and ultimately has that radical power to sever the parent-child relationship. And yet most foster children throughout the country, they do not have a lawyer advocating for them in their cases. And I tell you, we talk to so many foster families, kinship placements through our children's law clinic, and it is so common to hear them tell us when we pick up that phone to say, I feel like there's nobody advocating for the child in my home. And so we have sought to change that out here in Arizona. So the efforts out here in Arizona actually in many ways began in 2019. When my colleague Darcy Olson got a call from the White House and said, what are some ideas for making some really important reforms in this area? And one of the things that happened at the federal level was a change to the law that would allow states to be reimbursed for the cost of providing high quality child representation, lawyers for kids. And that change laid the groundwork for a bill, our signature bill that was drafted by my wonderful colleague, Rebecca Masterson, that provides a lawyer for every child in Arizona who is entering the foster care system. That law was signed this year by Governor Doug Ducey, and we're really excited to see it implemented. We're excited to be involved in the process of training the lawyers that are going to be appointed to serve these kids to ensure that they've got the highest quality legal representation as possible, and that they'll finally have a voice in court speaking for them, filing motions on their behalf, trying to get them the services they need, trying to push their parents to engage in the services that they need so that families can be reunited, shortening the time in care. There have been several studies of states and localities that do provide representation for children, and we know that children with lawyers tend to visit their family much more often while they're out of home care, that they exit the system 2.5 times faster than kids without legal representation, either being reunited with their biological families or having those rights severed and move on to adoption. And the last thing is that children with lawyers tend to be adopted more frequently if they can't return safely home.
So it's really important for people to understand this right to counsel isn't just about the initial stages of separating a child from their family. It has consequences for how that child will do post being in the system. And I think that's really important for people to know. So what are the other types of due process types of rights that you're working to protect? Because, if I was mentioning to my neighbor yesterday, there isn't even a requirement for them to seek out relatives within X amount of days, right? So what are the other kinds of things like that are in the system that you think we need to change?
Well, so, you just mentioned helping find relatives in a timely manner. So one of our signature legislative reforms that we've pushed here in Arizona and that has now been adopted in Georgia and Louisiana is what we call the Family Search and Stability Act, which really has two goals. Number one is to ensure that children who are placed in care are placed with relatives as soon as possible. And in fact, there is a federal law, federal requirement that state agencies seek out these relatives within 30 days of a child coming into care and to contact them and see if they're willing to take them as placement. But the reality is that requirement is so often ignored all across the country. And so our reform requires that agencies file with the court documentation of their efforts to seek out and find these relative placements as quickly as possible so that the judge and that the other parties can hold state agencies accountable for conducting that relative search. Because what happens so often that we see time and time again is that if that relative search isn't conducted, a child will be in care for a long period of time. Ultimately, if they can't return home, rights are severed. And then all of a sudden, a relative comes out of the woodwork that the child has no relationship with. And the courts and the relatives want to remove the child from a loving home where they've grown up. Maybe it's the only real parents they've ever known, and they want to disrupt that relationship. And so that's the second part of the Relative Search Act, is that we put in the law a presumption that the foster family is essentially kinship after 6 months with the foster family, so that if a family does come out of the woodwork after a diligent search, the court does not have to remove the child. And if the court determines it's in the best interest to stay with their foster family and ultimately be adopted by the foster family, the court can make that decision for the child's best interest. So we've got those twin goals of limiting the time, limiting the number of times kids are moved from place to place, as well as ensuring that they can be with families as quickly as possible if there is that loving, caring relative available to take them in.
And this is what it looks like if we are truly thinking about the best interests of the child, right? Which is a phrase that gets used so much in these conversations. So how can we go from making these statutory protections where state by state by state, how can this be at the same level of other constitutionally guaranteed rights that Americans have?
Yeah, well, you're so right to ask that question, because statutory changes is just one part of the equation. Ultimately, we're going to have to see courts recognize these kids are protected by the Constitution. They have constitutional interests and constitutional rights at stake in their cases. So eventually, I believe the U.S. Supreme Court is going to have to weigh in here. In fact, the court has an opportunity to recognize that kids have important rights and interests at stake this term. There's a case involving the city of Philadelphia's decision to terminate its relationship with Catholic Charities because the agency will not license LGBTQ individuals or couples as foster parents. And Jen Justice filed an amicus brief in that case, pointing out that there was a lot of argument going on in that case about the adults, but the children's interests were really being ignored. And so we urge the court to recognize that the 14th Amendment secures a child's interest in finding and forming families. And as a consequence, if the court were to recognize that, the consequence would be that the state would bear a heavy burden to justify any restrictions that were going to be placed on children's access to foster or adoptive parents. The reality is that any government action that reduces the availability of quality foster parents and families has dire consequences for these kids. Just too many American children are suffering as a result of not having adequate access to loving potential adoptive families. And so the court has an opportunity this term to recognize that the children's rights are at stake in these types of cases. And we'll see if they take that opportunity in just a matter of weeks. It's one of the handful of remaining decisions left to be handed down.
Wow, they must be thinking about it hard. So we'll come back to that, because I am wondering, if that case goes a certain way, whether it makes the right to counsel issue a lot easier too. So it's probably a sequencing here, but we'll come back to that, Tim. Thank you so much for sharing the work that Jen Justice is doing.